Go ahead, Kendra.
Hi, everybody. Good morning, and thanks for joining us. Normal with the impact that COVID has on our industry. So I would like to thank you for joining us today. So here's our agenda for the next hour. I'm going to introduce the amazing Tanya Walker. We're then going to turn our discussion to some housekeeping matters, such as how to use the Zoom features during the webinar. And if you actually haven't participated in a seminar with Walker Law, they like to make it as interactive as and engaging as possible, and it's a lot of fun. We're then going to dive into some substantive, many of you may or may not heard of. I love this topic, by the way, that can definitely impact our clients, and that is, when is a deposit no longer a deposit? Then we're going to discuss issues that some residential landlords should definitely be aware of. We're also going to discuss what happens if a mortgage lender backs out of their financial commitment to the purchaser before closing. I've had a couple of incidences where I've heard of that happening. We are also going to discuss condo liens and what to do if you believe that a condo lien is incorrect. And last but not least, we're going to turn to saving the deal. So we all know that we all work very, very hard to do the best job for our buyers and sellers. And then once that is done and the deal becomes firm, then we want to make sure that that deal closes for our clients. And so we're going to discuss 3 topics that have the potential to jeopardize your deal and how you can avoid those issues in the future. So for those of you that don't know me, my name is Kendra Connelly. I am with Sotheby International. I have over 17 years of experience, and I just recently last year founded the Connelly Group. Yeah, that's me. But more importantly, I actually want to talk about Tanya. So Tanya has been a trial lawyer for over 14 years, and she is the creator of Walker Law. She has successfully argued property disputes in various levels of court, including a court of appeal, which is the highest court in Ontario. Walker Law has a wealth of experience in dealing with real property disputes, and some of those disputes will actually be discussed by Tanya today. She has also earned a number of awards throughout the duration of her career, including a 2019 Osgood Hall Gold Key Award. I'd like that key myself personally. That's a great key to have. And Tanya also regularly appears as a legal expert on a number of TV stations, including CTV, CBC News, and City Pulse 24. So I'm just going to quickly go on to some housekeeping. Walker Law will be circulating an email after the webinar that will contain a brief survey. We spent a lot of time preparing for this webinar and want to make sure that you are getting the most benefit possible. So please fill out the brief survey and let us know your thoughts on the webinar and how we can improve. Everyone who fills out the survey will be sent a $5 Walker Law Starbucks gift card or a Walker Law branded face mask. So that Starbucks gift card is also like a little business card. So when you're done with it, don't throw it out, because that's how you're going to get in touch with Tanya. I would also like to mention that Walker Law has partnered with a charity which is funded by the federal government to provide used electronics to youth in underprivileged communities. This is increasingly necessary as many students are now studying at home and need the necessary technology so that they may learn. If you have old computers, tablets, or phones that you're no longer using, please reach out to Walker Law. They will arrange to have it picked up from you. And then Tanya's IT support staff will make sure that all of the data on the devices are completely deleted and wiped. And then they'll donate the equipment to the renewed computer technology. And as we all know, especially with what we have with the students happening right now, it's even more important that we get them these types of technologies. You're going to receive an email after this webinar, and it's going to contain information about upcoming Walker Law seminars where you can sign up for free. And one seminar that I'm going to mention is Tanya and I will be back here together on October 5th. And we're going to discuss new real estate issues as they come up as we continue to navigate through this COVID pandemic. So the roadmap for today is as follows. Step one, we will have a poll to help you understand, what your perspective is. We're then going to discuss the right answer and the law. We're then going to discuss how can we protect our clients. And then we're going to pause to answer any questions that you may have about each topic we're discussing before we move on to the next topic. So this presentation is customized, and if you have submitted a question when you registered, it will be answered in this webinar. But to keep things confidential, we're only going to use your initials that relate to your question. If you have any comments or questions, please type in the comment using the chat feature. It is on your screen. Feel free to type in the question as soon as you think of it. There's no need to wait until we're at the actual question. Is a lawyer with Walker Law and is in the picture that you see there, handsome man. We'll type the answer to you, and we will read out as many questions as possible, and we'll have Tanya answer them. So again, today's webinar is gonna feature a lot of polls in order to make the webinar more interactive and engaging. It's actually a lot of fun. I love Tanya's webinars. We include polls because we want to understand your perspective, and the poll menu will appear on your screen, and then you just select the answer that you think is correct, hit the please note, for those of you that are actually maybe viewing this webinar on a phone device or a mobile device, you may have a different experience than those of us that are on an actual computer when you're using the poll. So by the time this webinar ends today, you will have tips on how to protect your clients from ending up in court. This is gold, and I'm just so excited to have Tanya here with us today. So before we start the polls, Tanya is actually going to have a quick chat with us to provide some legislative updates that will definitely be of interest to you and your clients for sure. Hi, Tanya.
Hi, Kendra. Thank you so much for having me here today. I'm excited to present the knowledge that I have with real estate agents. So this question is actually from JM, and he wants to know, could you give me some legislative updates for real estate, particularly real estate agents? So on July the 6th, Bill 184, which is called Protecting Tenants and Strengthening Community Housing Act, was ordered for its third reading. So I will elaborate more on this bill later on in the presentation, but a summary is that it greatly amends the landlord and tenant law. On July the 8th, Bill 159, which is called Rebuilding Consumer Confidence Act, was debated at its third reading. This bill proposes changes to Terrion's Warranties Corporation to reduce the role of builders and provide more protection for customers. So what is important for you agents is that it causes the amendment of the Trust and Real Estate Services Act. It makes rules more modern for brokers and salespeople. The status of that particular law is that it received royal assent on March the 4th, and RICO expects that it will completely come into effect next year. So some changes in Toronto includes, before I get to Toronto, Doug Ford may announce stage 3 reopening today. So you should listen out for that later on this afternoon with the premier. So moving on to Toronto, electricity disconnections have been suspended till July 31st, 2020. In court, this is very interesting things that have happened. The state of emergency will affect residential evictions. So what happened is on July 7th, a judge made an order that whenever the state of emergency actually ends, right now we believe it may be July 24th, if you have in your hands an order to evict a tenant, whether from the tribunal or to evict someone because you have an order regarding a writ of possession, they haven't paid their mortgage, you will be able to enforce that on July 31st. So that's not a lot of time. What you should keep in mind is evictions are only administrated by the government. The government has a monopoly. So if you have an order, or your clients have an order to evict a tenant or to evict someone for not paying their mortgage, and the only entity you can hand it into is the sheriff, the enforcement office. And what you should do is hand it in right away if they will accept it. So you get first place in line, because we're dealing with quite a number of evictions. And so they only will carry out so many per day. So you might have to wait a few months for that person to be evicted. So now you know to get first in line and to get that person to leave the premises.
And that's hoping that a few months is the good outcome in regards to that backup that they may be issuing.
Exactly. It might take a very long time.
Yeah, I mean, for me personally, I'm predicting literally years, to be honest with you.
Yes, I don't know if they can take years, because it is a hardship to a landlord if a tenant isn't paying rent and the landlord has to continue paying taxes and utilities. So hopefully the government will hire more people, so then they can carry out evictions quickly.
Certainly going to be busy. There's a lot of new laws coming out, and once again, I think it's important for people to join us again on October 5th to continue making sure that we're keeping up to date with those laws and tracking them and just knowing how it impacts our industry. So this next topic is my favorite topic, and we're going to discuss deposits. And there's been a lot of issues around deposits, especially lately. But before we actually get to have Tanya to discuss deposits with us, we're going to actually have a quick poll. So here we go. A purchaser agrees to buy ahead of $175,000. The purchaser backs out of the deal and the seller is forced to resell the home, and the home sells for $800,000. What happens to the first buyer's deposit? A, the buyer loses their deposit and is responsible for some form of payment as damage. B, the seller doesn't get to keep the deposit and must sue. C, none of the above, and D, unsure. So submit your answer, and then Tanya's going to let us know what the correct answer is.
So we'll give it a few more seconds. And I will end it now.
So let's see, 65% Tanya said that the seller does not get to keep the deposit and must sue. And then next one was 15% coming in with none of the above.
So I'll tell you what the correct answer is. And the correct answer is B. This is not really a deposit, it is part payment. So the seller would have to give the funds back to the purchaser and then sue for damages in court for the difference between what the purchaser was originally, what the vendor was, the vendor must give back the money or agree that the money goes back to the purchaser and then sue for the difference in court. The reason why is because this is not a deposit, it is a part payment. The key factor here, what judges look at is what percentage of the funds paid to secure the property, what was that compared to the purchase price of the property? So in order to illustrate the answer, I recommend you take a few steps to determine whether the funds are really a deposit or purchase price or a part payment of the purchase price. So step one, you look at what percentage of the purchase price is actually the deposit. The court's golden rule of thumb is 10% or less is a true deposit. The vendor by default gets to keep it. So that's if it's 10% or less. You can see in this scenario, it's more than 10%, right? Because it's greater than $100,000. Step number 2 is if it's 11% or more of the purchase price, the funds may be considered to be part payment, and what happens, it must be returned. The interesting point to note here is if it's characterized as a deposit, and even if the vendor resells the property for more money than originally contracted to sell the property for, the vendor gets to keep it anyway. Why? Because the court has said that a deposit is an incentive for buyers to complete their responsibilities, and it's intended to help compensate the seller who may experience a loss if there's a refusal to close, but there is no need to actually experience a loss. So the case cited here is a leading case. It was decided in 1949, and it's still good law. It's decided by the court. It was decided by the Court of Appeal, which is the highest level court in Ontario. So moving from step 2 to step 3, what happens if the deposit is actually part payment? So if the deposit is part payment and you must return it, you really cannot, you have no case if you actually end up selling the property for more money because you don't have any damages. So in this situation where if someone deposited money to buy property for $1 million, and that person did not complete the sale, and then you end up selling it for $1.2 million, you have no damages, you have no entitlement to those funds. Right. Realistically speaking, by the time it comes to me, because I'm a trial lawyer, the vendor, the money has been deposited into a real estate lawyer's account or a brokerage account. It's not with us because we're litigators. And so the vendor usually says, when I explain that it might be part payment, well, Tanya, it takes time to resell the property. So I want the money, that's whatever it's called, I don't care. I just want the funds to remain in the real estate lawyer's account or the mortgage broker's account until this issue has been decided. Because all the judge will do for me is say whether I'm right or wrong. And if I'm right, all the judge will do is write a decision on a piece of paper saying I'm right and I'm entitled to a certain amount of money. Now it's up to me to collect it. And it's very easy to collect it if the funds remain in trust, because then the judge can order for the real estate lawyer or mortgage broker to release it. And so that's what usually happens, but there really isn't much of a legal basis to make that request that the funds stay in trust until that issue, whether it's part payment, if it's very clear it's part payment, has been dealt with, and to receive compensation from those funds in trust. So it's very important to know when a matter comes to us as trial lawyers, all judges we can deal with is our judges writing a decision on a piece of paper. So it's the takeaways from that. What I just mentioned is try to keep your deposits as low as possible so they're characterized as a true deposit. Try to describe what happens to the deposit in an agreement of purchase and sale. This is one of the first cases I actually argued in 2006, a long time ago. And I always thought to myself, when I get these type of matters, why don't they just address what happens to the deposit in the agreement of purchase and sale, so then you don't have to deal with me fighting it in court. So again, I'm just a trial lawyer. I'm not the one that would actually hold the funds in trust. So whatever entity is responsible for holding the funds in trust, you should run any phrase that you come up with by that entity. So one example that we came up with here is the paragraph that you see below. I try to keep it short, Kendra, but I wanted to make sure that I covered my bases. So time of the essence does not apply to this paragraph. The parties agree that should the buyer fail to tender on the date and time provided in closing, an amount reflecting 10% of the purchase price or the entire amount of funds in trust, whatever is less, shall be forfeited to the seller, and the buyer consents to this amount being paid to the seller out of trust. So then if you have a paragraph like this, it increases the chances of a purchaser, when he or she does not close because cannot get financing, the vendor can say, fine, instead of having a lawyer go to court and argue this for me, I can rely on a paragraph to have those funds paid out of trust and to me. So there aren't any guarantees that the mortgage broker or real estate lawyer will say this is strong enough, but at least you have something that I can use in court to say this is what everybody understood at that time. Mm-hmm. You have to also be careful because 10% is the golden rule of thumb. In British Columbia, which is not binding on us, nobody likes, like Ontario, we don't like being told what to do unless it's the Supreme Court of Canada. In British Columbia, there is a 20% down payment, and the purchaser deliberately said, I'm not going to close. And because it's 20%, this is just part payment, so give it all back to me. Judge didn't like that. Judge said, you know what? I'm going to use my discretion here. I'm not bound by that case in Ontario that says 10%, and I'm going to order for that money to be a deposit. And it goes the other side because you made a deliberate choice to not do something, and now you're hanging your hat on a technicality, and I don't like it. So you have to also be careful there.
Mm-hmm, mm-hmm. Yeah, that definitely, that when we had that discussion and you told me that, this just blew, like my jaw dropped on the floor, and I was like, everybody has to know this. Like everybody has to know this. This is gold. I love this. So yeah, thanks for sharing that information about the deposits. And it's good to know that getting the highest deposit possible for our clients who are the vendors is not always actually in their best interest. Especially when there's a possibility that the deal's not going to close. And obviously on give a little more, I guess, right? So, because then this way they increase their chances of getting it back. So I guess it's just going to depend on who you're representing at the time. So, but before we move on, I'm just wondering if anybody has any questions about this.
Yes, there is one question, Kendra, and it's from KM. KM, thank you for the question. The question says, how do you know when to use this paragraph, when to use a paragraph like this? Do you recommend it go into all of our deals? It depends on who you're representing. Right. So I'm an advocate. It just depends who I'm an advocate for, the defendant or the plaintiff, the vendor or the purchaser. So definitely if you're representing the purchaser, I would not have this in the paragraph. I would not recommend having this paragraph in your agreement of purchase and sale. But in a situation where you represent the vendor and there might be some cause or uncertainty whether the purchaser will have the financing to close, you don't want to be stuck in court dealing with this, because another point is sometimes even when you win, sometimes you lose. Because again, because all the judge writes is your decision, the judge also can say whether you're entitled to some payment of your legal fees for having me go to court to deal with this, but it's up to you to collect it. So it's another way to save yourself, but really it's for the vendor, not the purchaser. The purchaser might want to have in that agreement where if they don't complete the purchase, they might get 5% back. I had a matter where I represented the vendor, and because due to the cost of litigation, we actually resolved our matter with the purchaser by giving them a certain percentage of the deposit back to them, even though, and that was a true deposit and my client was entitled to the entire amount. We took into consideration legal fees. The purchaser didn't have any assets to collect. And we said, you know what, just give them like 10% back so we can move on with our lives and keep the deposit. So it just depends on who you represent. Go ahead.
Well, I was going to say, I definitely can see, like, yes, when I'm representing a vendor / seller, and I might have some just indications or a gut instinct that the seller's financing is a little sort of maybe wonky and not 100% and so on. But also, especially nowadays, when we have heard of lenders reneging on their commitments to lend money to complete a sale. So, I mean, it just depends on each case by case basis.
There's another question from GS, which is like, what issues get sellers into litigation? Are they sued jointly with real estate agents and legal representatives? I would assume that that's what it means. I'm going to cover quite a few issues that sellers get into litigation about, but there's one issue that isn't part of this presentation that I've presented on before, and I can send you the link and let you know where to kind of move to get to that exact minute, where you have issues of defects that are not disclosed. So if there's mold and it's not disclosed, termites not disclosed. Those are issues that sellers can get into. And sometimes judges have said real estate agents might be responsible for that as well, because it just depends on the role of the real estate agent, if they're representing both the buyer and the vendor versus just the vendor. And so there are some issues that sellers get into litigation. And so I'll try and cover as much as I can today.
So Tanya, let me ask you, what do you do in the situation, say, where a buyer has sold a home and a tenant won't leave? So I understand that the court is backed up and that can affect the closing, but like, for an example, I've just had this happen. I just sold a unit representing the seller yesterday, and I just sold the unit and there is a tenant in there. And at the moment we are all getting along and I feel like the tenant's going to be moving forward in really good faith. But of course you just never know. So what do we do?
Well, if the tenant refuses to leave, the courts are dealing with matters just on a limited basis. And the arguments, interestingly, the arguments that I've dealt with the court since COVID has started are all property issues. And so property issues seems to be an area where a judge will listen to you argue because it's an emergency. And what would have to be done in that situation if the tenant refuses to leave is to bring a proceeding before a judge in emergency court. So step one, you have to explain why it's an emergency, and the judge may or may not agree with you, and then gives you permission to argue. And that has happened before, since COVID has started. A tenant was actually evicted before COVID started, and then after COVID started and there was a pause on enforcing writ of possessions, the tenant broke back into the unit and said, I'm not leaving because now there's a pause in enforcing writ of possessions. And the judge said, no, you can't do that, get out. So the court said this is an emergency, and they just don't like when you try and manipulate things.
Of course. So a question that's come up against my fellow colleagues who own property that they rent out is what can we do about tenants not paying rent? So before Tanya tells us what the law is around that and how, if you are a landlord, how you should move forward on this, I'm actually really curious to see what everybody else thinks. So we have our next poll, and the question is, the tenant has not paid rent since the beginning of the pandemic. Since the tenant currently cannot be evicted, is it possible to get a court or tribunal order to recover the outstanding arrears? A, yes. B, no. C, unsure.
We'll just give everyone a few
So
seconds.
if you can pick from one of the answers, and then Tanya's going to let us know which one is the correct one.
Okay, I'll give about 5 seconds and then I'll end the vote. Going once, going twice. Everybody always votes when I say that. Okay.
So Tanya, 67% of our participants are saying yes. Yes, you can go to court.
So the majority of you are correct. The landlord can recover its arrears. Many landlords have experienced a bit of a crunch when it comes to non-paying tenants, or even before the pandemic. So when COVID-19 happened in Ontario in about March, one of the first steps that the government took was to stop residential evictions. The purpose of stopping this is because there was a concern that there would be mass layoffs, people would be evicted from their homes, and that would increase the spread of COVID-19 if people don't have anywhere to live or they're looking for somewhere else to live. And so many residential tenants and tenant groups interpreted this to mean don't pay rent during the pandemic. And I don't believe that understanding is correct. Landlords can continue to seek unpaid rent, and landlords and tenants should work together to discuss arrears of rent and paying it. And because of the financial strain that has been placed on landlords, the government has now proposed Bill 184. So there has been some controversy about Bill 184. You might have heard last week people were protesting out of Mayor John Tory's condominium because of this bill. Keep in mind, he doesn't have any jurisdiction over this bill. It's a province of Ontario. But for our purposes, I'm going to focus to date on the Residential Tenancies Act in terms of explaining to you the proposed changes. One is that landlords are able to apply to the Landlord and Tenant Board to evict a tenant for non-payment of rent during a pandemic. The landlord who submits that application must demonstrate that they try to work out an agreement with the tenant. And if an agreement has been agreed on, then that must be submitted to the board, which might form part of an order from the board. And this agreement also can take into account payment of outstanding rent. While there's in Ontario, we're still sorting out the details, we can look to other provinces to see what kind of expectation the tribunal will have regarding working out an agreement. In Alberta, this is actually in law right now, and this requires landlords to show that they've taken into consideration the financial constraints of the tenant. So this really needs to be approached by a tenant basis. And if a landlord really shouldn't try and get a tenant to agree to pay something they cannot afford. Someone who's lost their job, you may want to have a payment plan that takes that into account, and maybe arrears of rent will be paid several months from now instead of at the moment. So the pandemic has caused a lot of uncertainty, and one of the reasons why tenants aren't happy with Bill 184 is because of that pressure. But I don't believe that there will be that pressure, because you have to take into consideration their financial circumstances. So we have to also consider the reality of things. The landlord-tenant board, personally, may not be the best way to go in terms of getting an order for arrears of rent. Once a tenant has left the premises, you can sue in small claims court. Small claims court is not as backed up because you can file your lawsuits online. It's never stopped. You've always been able to file your lawsuits online. And so you might be able to receive a decision earlier than you would with the landlord and tenant board. So just to discuss some practical tips for you or your clients on negotiating, keep in mind, find how much they can afford. Keep in mind also forgiveness that you may have received. So I explained earlier that the City of Toronto is not disconnecting electricity until July 31st. So there's been a period of time when, if you are the landlord, you weren't as, or shouldn't have been as worried about electricity because you didn't have to pay it. It was deferred essentially. So you should pass that deferral on to your tenant. You want to come across as being as reasonable as possible. And you always can have an agreement that's effective for, say, 2 months with an agreement to revisit it in 2 months' time. Make sure you write everything down. The most difficult part of my job when it comes to litigation is proving a handshake. So please send emails, send text messages. They have been used by judges. They've been relied on by judges. It's better than nothing. Even if the tenant or landlord will not respond to you, just send it anyway. Make sure you have a read receipt if it's an email, so then you can show a decision maker how reasonable you were.
Mm-hmm, mm-hmm. Yeah, I mean, the pandemic has obviously been really hard on both parties, on landlords and tenants, and hopefully they can continue to work together to come to some sort of agreement with one another and have it be as amicable as possible. I wish the government had sort of maybe put in a few more sort of guidelines for landlords and tenants, because it's hard when you just leave it up to everybody to figure it out on their own. So before we move on, does anybody have any questions about this topic?
Well, it seems like we can move on.
So the next section involves a topic that I'm starting to see definitely become an issue. I've heard of it happening a couple of times. It makes me nervous myself as a recent home purchaser. And that is what happens to the agreement between a vendor and a purchaser if for whatever reason you no longer qualify, Mr. Buyer, and then the buyer can't close. So we're going to do a poll, of course, on this one. And the question is, the purchaser had a lender promise to provide funds for closing. The market went down and the lender pulled the financing. I mean, I can also see this really start to happen again in the future. The buyer will obtain the funds after the closing date. Must the vendor accept the later closing, although this is not addressed in the agreement of purchase and sale? A, yes. B, no. C, unsure. So put your vote in.
We'll give everybody a few seconds to vote. So about 5 more seconds.
So see, 53%, 26% with unsure. I hear you, people.
So there is the combined yes and unsure is the other 50%.
Yeah.
So I will explain to you what the correct answer is, and the answer is B. So no, the vendor can sell to a different purchaser. The vendor is not obligated to wait until the purchaser obtains additional financing. The reason for that is that time is of the essence. So most of you in your agreements, you have a paragraph that speaks about time being in respect of the essence of the closing. And that means that there's no extension of time that will be given. And this has happened actually before in a case called Time Development Group versus Bitten. So in 2018, the purchaser said the vendor had an obligation to wait until the purchaser was able to obtain alternative financing. And the court said, no, the vendor does not. This is not the vendor's problem. The vendor does not have to be punished because of what a third party, a lender, is going to do or backed out on. So given that this is a problem I see quite a bit nowadays, you might want to resolve this with including a phrase. And the phrase, again, this is not written in stone because I'm a litigator. This is what I can see. Something along the line should be in here. But the phrase should be, the vendor agrees to extend the date for this agreement of purchase and sale by 30 calendar days. You could pick whatever number, 90, 60, whatever, who have committed, if the mortgage lenders who have committed to providing closing funds to the purchaser withdraws their commitment within 20 calendar days prior to the closing, despite paragraph 20 of this agreement. So you could also even say in the agreement of purchase and sale that time of the essence does not apply when it comes to obtaining the funds for closing. You want to address it somehow so then the purchaser has the ability to close.
That is brilliant. I will definitely be using that one for sure. It's always frustrating to have a deal impacted, obviously, by the vendor. I was floored, to be honest with you, the first time I heard of it happening, where it was just like all of a sudden the vendor just pulled the financing on the poor buyer. But before we move on to the next topic, does anybody have any questions about this one?
There's one from LC. So LC asked, does the buyer lose their deposit in this situation? So thank you for your question, LC. I'll answer it now. My thoughts, yes, the buyer does lose their deposit. This is if you use your standard agreement of purchase and sale. That's why I put that example after the first one. The buyer did not close because of financing. And therefore, if there was a true deposit, it's not characterized as part payment, regardless of how much the property is sold for in the future by the vendor, the buyer does not get the deposit back. And again, this is not automatic. If you don't have something that addresses this in your agreement, you have to get an order from a judge. So I hope that answers your question.
So, but Tanya, sorry, even if it's more than 10%?
No, if it's less than 10% or less, it's a deposit.
Right.
The courts don't care if it walks like a duck, it talks like a duck, it's a duck. You can call it a horse, you can call it a zebra, it's a duck. So yes, thank you, Kendra. If it's less than 10%, that will be characterized as a true deposit, and the courts will. I mean, the Court of Appeal is the highest level court in Ontario. It binds lower level courts, superior court judges. So the purchaser will lose the deposit if it is a true deposit.
It looks like we have another question from MD, and MD is asking for any tips on safety with viewings when you buy and sell.
Yes, so there are a couple of things. One is that you should have everyone wear a mask. You should make sure that you limit the amount of people that are in the home when you're, I assume this is when you're viewing it. You probably don't want children in the home, or if there are two people going to purchase the home, maybe just one partner and the other person can participate via FaceTime or Skype. You also want to make sure you control your breaths. And what I mean by that is if you're wearing a mask and the other person's wearing a mask, even if you pass each other in the hallway, if one person has COVID or is a carrier of COVID, the more you breathe in, the higher probability you have to contract COVID. So you might want to just, if you have to pass somebody closely in the hallway or on your way in or on your way out, you may want to just slow it down with the breathing or even hold your breath. Don't discreetly, not just make it very discreet so people don't feel uncomfortable. You also may want to consider signing some kind of disclaimer. I don't know how enforceable that will be, to say, have your people who attend the property say, I don't believe I have COVID. If they're comfortable, maybe take temperature. If they're comfortable. You would also want to make sure that the people that own the property, if they're still living there, they leave as early in the morning as possible, and that you schedule a viewing as late as possible, because it's said that COVID stays in the air for 4 hours, right? So if someone sneezes, the particles are in the air for about 4 hours. So the chances are that if the owners of the property leave early, you view it much later, you reduce that chance. Also try and get people not to touch too much and see if you can disinfect before and after showing.
Yeah, I'm actually providing little PPE kits at the door with my listings that have a mask and gloves. I even have little booties, like the little plastic booties for people to put on their shoes as well. But I think that also sellers and buyers that are visiting homes also have to understand and take into account, we are relying on the integrity of the buyers that were there before you. And even though we can ask and we have you sign a COVID disclosure and all that good stuff, I'll give you an example. I saw a buyer go into a house yesterday and he was not wearing a mask, gloves, nothing. And he refused to put it on. So he still went through the house. And so, I think we have to keep that in mind, right? We're relying on the integrity of the people before us. So we have another question from JC, and he's asking, are there any COVID-19 issues that you can see on the horizon? It's not an open-ended question.
Well, I've mentioned quite a few in the webinar, but one thing I didn't really mention, and thank you for your question, JC, is contacting COVID. So if in a situation with the face mask, if a prospective purchaser believes they contracted COVID from viewing that property, would they be able to sue? And the reason why I see this as a potential issue is because the Ontario government is talking about having legislation where you're not able to sue your employer if you believe you contracted COVID on the job. But I don't know if that would actually extend to someone viewing property. So that's an interesting point, and it's a very novel issue. So we just have to see, and maybe that's something we'll have to talk about on October 5th, Kendra.
Yeah, I mean, it'd be very interesting for sure if we start to see some cases come out of this. That's just, you never know, right?
Right. Oh, there's another question by LC. This is a question regarding commercial tenants during COVID. If they give notice that they've ceased their business and have a lease for 7 more years and have not paid for 3 months, what are the landlord's right and how should they proceed legally? Well, do you see that one, Kendra?
Yeah, I see it.
Yeah, so thank you for your question, Elsie. And I'm glad you clarified because I reached out to you earlier because I want to know exactly what you wanted me to speak about. It depends. If sometimes with commercial leases, there's a personal guarantee. And so if there's a personal guarantee, the commercial landlord can sue for the remaining rent that was due and for the rest of the 7 years. The expectation of a judge, though, is that you're going to try and minimize your loss. So that means you're going to try and get out, and it's called mitigation. Judges don't like when you sit around and wait for them to just say you get a check. So if the tenants have left, the expectation, even though the market is not the best right now, is that they're actively looking for someone else to be in there. So then when you look at damages, when you actually get before a judge, your damages are the difference between what you're going to receive for rent during the remainder of the lease and what you actually receive. So if you charge $10 a month now and you find somebody to get in there that's $5, your damages is a difference. So it's important to mitigate. That's what they call minimize your loss. And if there's a personal guarantee, to sue. If there is no personal guarantee and you have the lease with a numbered company, a corporation that doesn't have any assets, you have to look at the reality of suing because you may not be able to collect. It may not have any assets. So there's a few things your client should consider before they sue. And the most important is whether you're going to end up with a check at the end of the day. I hope that answers your question, Elsie. Okay, so should we move on?
Sure. So scope of condominium liens. So many of us either are condominium owners or we've owned condominiums at one point, or we're even planning on becoming one. And I think a lot of our clients want to know the scope of the condominium management authority. For an example, I mean, not talking about a lien, but just for an example, Tanya, one of the things that we've seen as well is all of a sudden some property management companies saying, no, you can't have any contractors into the building, real estate agents can't show the property, or I'm with myself being on a board myself, that did come up. How do we protect the homeowners? Can we stop people from just coming around? So again, just that, what is the scope of a condominium's management authority? So we've got one more poll that we're gonna go on. And the question was submitted by TWNBR, and this is a good one. The condos management is imposing a $10,000 fine for breaking a rule without any evidence and are threatening to register a lien. Should I pay the fine? A, yes, B, no, C, maybe, D, unsure. I mean, I just want to say no. So everybody can vote?
Yes, about 5 more seconds. So going once, going twice. All right.
Oh, look at that. 67% agreed with me. No, you shouldn't pay the fine. 67%, that's pretty good. 24% said unsure. And then we had maybe and yes at 5%.
I wonder why people said no. I guess you'll let me know why you thought no, Kendra. But
well, I was more along the lines of like, well, no, you don't have any evidence. So like, no, I'm not going to pay it.
Oh, okay. Oh, okay. So the correct answer, I'm sorry, Kendra, is C. And so the answer is maybe. Oh. And Elsie, I saw that you sent another question. I'll answer it at the end of this section on the questions portion. So C is maybe. So why I say maybe is it depends on what the bylaws say, right? Do the bylaws say that this kind of lien can be put on the property? If it does, then maybe you might have to pay it just to minimize any damages that you may have, which what I mean by that is if you're in the process of selling it and there's this lien on the property, even if you disagree with it, it might make sense just to pay it out and deal with it later on. So you look at the bylaws, if it allows for this, then you may be responsible. And you usually, just because, I should add, because I represent a few boards, just because the bylaws say that this can be done does not mean a judge will say that it's fair. So in this situation, yes, you should pay, but you might have to challenge this with well, first of all, you should discuss it with the board to see if you can resolve it. Always try to resolve it before you go to court. And if you aren't able to resolve it, then the next step is to say to a judge, I don't believe, there's no evidence, and this bylaw is not even fair to begin with. I want you to like strike it down, to say that it's unfair. And so a judge may do that. So practically speaking, we don't think it's right to just run into court. Always see if you can work it out. And you should keep in mind there's also the Condominium Tribunal, and the Condominium Tribunal is a part of the Condominium Authority of Ontario, and it provides information and training. Right now, the jurisdiction of the tribunal is dealing with record keeping. So something like this, and many condominium disputes are outside the jurisdiction of the Condominium Tribunal, but they have been talking about widening their jurisdiction, because this is an issue that comes up quite a bit, and it's really not fair for the person who was charged improperly to pay quite a bit of money to fight this in court.
Well, I have to be honest with you, Tanya, with myself possibly becoming, or actually with myself becoming a landlord very, very soon, but also in situations where I am representing landlords, I feel like this would be something that I would put into the agreement in regards to if my tenant did something that caused me to all of a sudden be put in this position where I'm being issued a fine because I'm the homeowner, that they would then be responsible for paying it.
Right. And so what I have on this slide at the bottom, because you led me right in.
Ah, yay.
Is that, I mean, if you have a tenant, you should address this in your rental agreement if you have a tenant. But realistically, a judge, if you would challenge that, if it were an infraction, like they said you caused the infraction, then a judge may expect you to do that on behalf of your tenant as well. So it doesn't really matter what your agreement says. If your tenant caused, or they say your tenant caused a problem that resulted in a $10,000 lien on your property, and it was an unfair, you believe it was an unfair bylaw, or they didn't have any evidence, and you would have challenged that personally, a judge may expect you to challenge that on behalf of your tenant and not just charge your tenant for the funds. So if you can't resolve it, you might have to start a court application. A court application is different than a lawsuit because you get a date to argue right away. Normally it's about 3 weeks from now, and you would have the judge declare whether the bylaws were unfair, declare that the charge was unfair. It's a declaration. That's why you get a date right away, because you don't really have to testify or anything. So that's the recommendation, but it really shouldn't get to that point. Hopefully you can work that out. So before we move on, I just want to answer Elsie's question. And she asked, she's following up to the commercial lease question, and she asked, should the landlord lock the premises and seize the chattels and leaseholds? So landlords only have two options, and I just dealt with that in court last month with a commercial landlord. You either can lock out the tenant and seize the chattels, or seize the chattels. You can't do both. So the situation that I just dealt with on behalf of the landlord was when the landlord locked out the tenant and took the tenant's stuff, and got really reprimanded by the judge for doing that because it's contrary to the law. So if the rent has not been paid, you can tell the tenant, I'm going to change the locks. You can't be in there anymore. I accept the breach of contract. It's at an end, because just because someone's breach of contract doesn't mean that you actually have to accept it. And then you can, then they can get their things and move on. But you just can't do both. So you have to make sure you comply with the Commercial Tenancies Act, because I don't find judges are being very sympathetic with commercial landlords nowadays. I don't know if it's just the climate, but I like having dealt with a judge not too long ago regarding this issue. he wasn't happy with what the commercial landlord did. I hope that answers your question. Any other questions?
Okay, so last but not least, avoiding any issues that may affect the deal. And as I sort of introduced this at the beginning of the webinar, which was, as agents, we work very, very hard to get great deals for our buyers and sellers. We put a lot of time and effort and care into these deals, wanting to make our clients' dreams come true. And then it doesn't end there. At the end, we have to close that deal, and we have to sort of sometimes find ourselves in situations where we're dancing on hot coals to get that completed. So if anybody has, again, any questions in regards to this, feel free to use the chat feature. We do have a question from KM, and that is, what are issues that I should be on the lookout for to make sure that the remainder of the real estate transaction goes as smoothly as possible, and that the closing of the transaction occurs without any problems?
So I'll keep this brief because we only have about 5 more minutes. This one issue that may affect closing a deal is when there are liens on title. So I dealt with this. This is a case that I argued in the middle of March, right after COVID started. And what happened in this situation was that my client wanted to sell her property, and right before closing, she discovered that there was a judgment for $25,000 registered on title to her property by her ex-father-in-law. Her ex-father-in-law sued her and obtained judgment without her knowledge while she was going through divorce proceedings. So what would have happened is the property would have sold. The ex-father-in-law would have received a check for $25,000 from her proceeds, and he doesn't have any assets here in Canada. He doesn't even live in Canada, and good luck later on trying to get that money back. So what I asked the judge to do was make an order to lift the lien and to have the $25,000 paid in our trust account, which happened. Unfortunately, the judge did not order legal fees to be paid. Usually when you win, you can ask the judge to order 60 to 80% of legal fees to be paid. But the judge said in this situation, Ms. Walker, you gave 2 days notice of this. The person didn't have time to defend. So I'm going to use my discretion, not order any legal fees to be paid. So I wondered to myself, why wouldn't you do this search even before you list the property? So if there are any issues, you can deal with them and you don't have to worry about emergency court and not even getting costs. And so there's one thing you can ask a real estate lawyer to pull, which is a title search. And it's called a parcel registry search. And it's actually helpful in some of my cases because sometimes we sue someone and then going through the lawsuit, we realize they transfer title to their mother for no money. They're getting rid of assets. So what I've done in the last year about 3 times is bring a request to a judge showing this, saying we're actively involved in the lawsuit. Here's the proof that it's a weak lawsuit for them. Could you please freeze this? Because they're obviously trying to get away without paying a judgment. And so there are a couple of matters where their property's frozen because of this. So if you look at this, what's before you, you can see that, and I'm just going to focus on the last circle, that there's a lien on this property. It looks like the person didn't pay their taxes. So we redacted out the confidential information. But this person, if you're going to sell your property and there's a lien for not paying your taxes, that's Her Majesty the Queen, the Minister of National Revenue. What's important really, the Queen's important, but national revenue, that shows taxes. You might want to get that sorted even before you list the property. So other issues that may affect closing your deal is zoning, obtaining subdivision approval, and inspection. And to summarize here, that means that if the vendor has an obligation to do certain things, such as get zoning, you can't then back out of it because you don't want to do it or it's too expensive. That's happened before where the vendor said, it's going to cost $600,000 to get the zoning. I don't want to do it anymore. And the court said, too bad, you agreed to it. So if you want to help save the deal, you should have in there a sole discretion paragraph where that person has a sole discretion to decide whether or not they're going to want to do this. And that's happened in a situation called Marshall versus Bernard Place, where the purchaser said that closing was subject to their approval, and there were minor issues like caulking, and the judge said, it's fine. That's what they put in there. That's what you both agreed to. So they don't have to close. Good enough title is also another topic that we'll discuss more on October 5th. But in that situation is, just because you have that phrase, that's your standard phrase in your agreements, there's a gray area with that. And so I dealt with a matter where my client closed on the sale of a property, although he found out that there were tiebacks installed underneath the property to secure the property to the ground, because the builder was doing work nearby and the place would shake. And the purchaser did not find out about this agreement until the day before closing. And so because there was a gray area, he closed and sued. And we ended up, what you take into consideration with settlement is the reduction in price of the property if this had been disclosed, plus legal fees. And that was quite significant.
So Tanya, if I can just jump in there with two things that I think are really advantageous for my fellow colleagues to know. As we had discussed, going back to that sort of title search, partial registration. A lot of agents I know what you're saying already. You're saying, but isn't that what my real estate lawyer does on a title search date? Well, yes, to a certain extent. However, I think there's two advantages to doing it ourselves, which I've learned from Tanya, which is number one, if we do it ahead of time and we see that there could be some potential issues down the road, we can get started on those right away, which I think is just advantageous in us doing a great job for our buyers or sellers. But number two, when we do get that partial registration and you can see that there's either a lien on the property, or you can see how much money is owing on the mortgage and this and that and the other, you can use that for negotiations. So that for me was just right there and then, sort of like, I love that. And then again, when we're talking about sole discretion, and maybe we can touch on that again on August 5th, but in regards to when is sole discretion advantageous for a buyer, or when is it advantageous or a disadvantage for a buyer or a seller, either or. So I think we'll make sure we touch on that one on August 5th as well.
Yes, and so moving on, there's a question. Well, I want to answer the live chat question first.
Yes.
If a property has bed bugs and it's remedied before closing, does it have to be disclosed to the buyer prior to closing? Thank you, SM, for that question. I'm not sure if it's a defect that needs to be disclosed or not, but I would exercise caution and disclose it anyway. Because you don't want someone to say that this is a defect that you knew of and you hid. So I probably would be a little bit cautious and disclose it, unless there's absolutely no bed bugs in the premises anymore. Another question that we received is from LW, talking about a memorandum offering when you engage with landowners for redevelopment of land. Some things you might want to take into account is zoning, like I mentioned before, environmental audits, the purpose for the use of land, when you will close, who's responsible for real estate commissions, and assignment of the agreement. Sometimes people assign agreements, and you should really agree on whether it will be assigned or not before you provide that memorandum of understanding.
So for those of you that were not able to join us at the beginning of the webinar, I'd like you to know that you're going to receive an email that's going to contain a link to the recording of the webinar, along with the survey, so that we can get your feedback. And I'd like to thank everybody for their time. And Tanya, thank you so much for your time. I mean, again, to me, it's like your time to me is liquid gold.
Well, thank you, Kendra, very much for having me. Thank you.
So I just think it's
great. Thank you to all the agents for participating. It's great to share the knowledge that I have, and hopefully you won't need me, but if you do, and hopefully you won't need me, but if you do, then I'm here to help you. But I always thought to myself, well, why didn't they do this or why didn't they do that? So I'm happy to help.
Well, definitely having access to a litigation lawyer is definitely, like I said, it's advantageous. And you know, last week I had a question for my real estate lawyer, and I just wanted to double check their answer with Tanya to make sure that my seller was safe, and Tanya's answer was what made me feel safe moving forward for my seller. So again, just having access to you is amazing. So thanks everybody for joining us, and thank you, Tanya, and we'll definitely see everybody again on August 5th.
Yes, October 5th, not August 5th.
October 5th, sorry.
That's too early. Thanks everyone. Have a great day. Bye guys.
Bye.